hello, hello.
And welcome to the Hildebrand Law Firm topic for today.
And today we are going to continue discussing something that we started off last time doing, and that is talking about those beneficiaries that we want to name in our estate plan, and they may be disabled according to the federal law, or they may have issues that you consider to be of concern with respect to them inheriting directly a large amount or even a small amount of funds.
And those type of issues, the reason that we want to make sure that those are addressed is because the main thing is that if someone has any of these issues, and we'll go over a list of issues that we have included in our trust, just because these are issues that people come to us with all the time. But the main reason that we want to make sure that these are addressed is not so much to protect your money. Money will come and go. The main thing that we want to protect in all of our estate planning is the family, especially with some of these definitions that we'll go over. The last thing that these individuals should ever have direct access to is money if they're ever in a situation like that. So, Kirsten, do you want to talk about what some of these definitions that we've come up with for disability or incapacity?
Yes, absolutely. And so I think that last time we discussed the fact that you can and should have an estate plan for anyone who falls into this large category of disabled individuals, because you really should not rely upon things lining up perfectly to allow for a family member to be able to take care of somebody who you don't want to have inherit directly because they'll be kicked off their benefits. But what if you are concerned about someone who has not qualified for any federal benefits, but you still don't necessarily want them to receive funds because they are going to, as you were just saying, Matt, harm themselves potentially or harm others by utilizing funds in an inappropriate way? I can think of a situation where there was a young man who was in a terrible car accident. He should not have survived. He did. He survived to the extent that his brain injuries allowed him to work, but not to be able to process, say, anything esoteric. So, for example, he was a machinist and he would go and he would do his machine operating. But his father told me that if you gave him $100,000, he would literally go to the corner of the road and hand it out to everyone because he had no concept of money whatsoever. So, what I talked to him about was making sure that we put into the trust a definition of incapacity or disability that would encompass something more broad, such as that particular situation. And so, for example, it's a very good idea to have in your estate plan a disability panel. And the disability panel that you identify as the person who's making the estate plan is a group of, say, 3 people who would all have to agree that the individual is in fact considered to be unable to manage their funds because of a variety of behaviors. And so it's more of a focus on behavior than it is a focus on a medical condition.
Right. And so this is going to sound like a joke, but this has happened 3 times now. The amount of people that have come to me and say, yeah, I'm a little concerned for mom because at 3 in the morning, she answers the emails from her cousin in Nigeria who just needs a little bit of Bitcoin in order to get home. She answers those emails in the affirmative. She doesn't even know what the heck Bitcoin is, but she sends him money. And then all of a sudden, where'd mom's money go? And so that's where the disability panel can get together and they say, you know what, mom, we understand, things are happening right now. What we're going to do is we're going to take the keys away from you, so to speak, so that you can't drive and potentially hurt yourself or hurt any of the property that's within the trust. Because even if, as you're going on throughout life and things start to slow down up here, your original goals may not be upheld if you start making poor decisions with the property inside of the trust.
Yep, that's exactly right. And so some of those behaviors are, what if somebody is has disappeared or is absent for a period of time? Or what if they are only able to hold down a job for a really short period of time and then all of a sudden they're back out of work again with 20 excuses? Or what if, and of course nobody wants to talk about this, but Matt, have you had an estate planning family that has come in who doesn't either A, have a drug, alcohol, or gambling, or shopping, or some other type of financially related addiction, maybe not even within their direct beneficiaries, but potentially with the grandchildren or the secondary contingent beneficiaries if somebody were to predecease them. I think it's
Absolutely.
unfortunately it is so rampant at this point. You don't know what a 16-year-old is going to do.
Right. Right, and that's the thing. And one of the points that I always try to make across to people is that, especially with if you have a minor who's a child or a grandchild, and you plan on leaving money to them or their parents, and you never know who's going to be the beneficiary. You never know if a child's going to predecease you. You never, even if you provide for grandchildren in your plan, you never know. And so you never know. They're 16 now. They're great kids. They're in high school. You just don't know that when they grow up could they become addicted to drugs or alcohol? Every drug addict, every alcoholic, every person who's gone missing, every person who can't spend money at one point, I'm sure, was a decent kid. And
That's a very good point.
so it's really difficult to tell. And so that's why a lot of people come to me and they say, I want to put contingencies in place so that if this does ever happen to my child or my grandchild, I want to make sure my money's protected, but more so, I want to make sure they're protected.
There, and the other end of this is, what if there is a child or a beneficiary who might be going through a rough patch right now? It reminds me of a client that we had recently. Wonderful, wonderful woman, probably in her 60s. Her 30-year-old son had a significant drug and alcohol addiction that started when he made one bad choice when he was in high school. I tell my children, you are always one or two bad choices away from a completely different life. And kids don't understand the gravity of some of their choices. So he did that. And even though he has a great family, he went on a path that ultimately led him into a recovery mode. And he had been recovered and sober for approximately 2 years. She was very excited and grateful for that. But she told me confidentially, I don't know if this is going to 100% stick. I just don't know, because the chance of having a relapse is so high in the area of alcohol and drug abuse that how can I make sure? Because if he's doing fine when I pass away, I don't have any problem with him receiving the money outright, and especially if he's got 20 or 30 years of sobriety under his belt, more than likely he'll be fine. But what if he's not? Is there a way to give the power to a trustee to be able to make the decision at that time instead of having that to make that decision now? And I was really pleased to be able to tell her that within our estate planning, we can develop that. We can make sure that we put a plan in place where the trustee makes a real time decision to analyze that and see where things are at.
Exactly. And so there's a couple of things that I want to mention. I think that's a wonderful story. One of the things that I want to mention is more anecdotal to maybe perhaps me and my generation, but a big issue that a lot of my friends have is sports gambling. Gambling is huge now, especially now that it's been legalized in a lot of different states. I have a lot of friends that text me every single weekend. They text me a screenshot of all the bets that they're making on football games and all of that stuff. And I think they're out of their minds for some of these things, but they love it and they lose a ton of money. I'm sure no one ever tells you about all the money that they lose. They tell you about all the bets that they hit, of course. And so the big thing that we want to prevent against is, what if you're to pass away and you have a child or a grandchild as a beneficiary and they're really deep in sports betting and maybe they owe money or maybe they're just obsessed with it and they get a whole influx of cash, which is what happens if you don't have your estate planning in place. This will probably be another video for another day, but if you just rely on designated beneficiaries and transfer on death and payable on death, you think your 401k company cares that your grandson is addicted to sports betting? Nope.
Nope.
You think your bank account, your bank company cares? Nope. They don't care what's going on in your kid's life. They don't care if your kid has an alcohol issue, has a gambling issue, has a drug issue. They're getting a check, no questions asked. With doing proper estate planning, you have someone in control of determining whether or not that person is fit to receive whatever money you've allocated for them. So that's why something like that is so important.
Very, very good point. Having stopgap measures in places and contingency plans is the hallmark of an excellent estate plan. And that's what we're committed to doing here at Hildebrand Law Firm. We want to make sure that we protect your today and tomorrow. Thanks so much for joining us and have a terrific rest of the day.